Hello and welcome everyone to Consent in the Law as part of Victorian Law Week. I would like to begin by acknowledging Aboriginal and Torres Strait Islanders peoples as the first people and traditional owners and custodians of the land and waterways upon which our lives depend. I acknowledge and pay my respects to their ancestors of this country, elders, knowledge holders and leaders past and present. I extend that respect to all Aboriginal and Torres Strait Islanders people. My name is Jasmin. I am the Education Coordinator at the County Court. Some of you may recognise me if you've been to one of our digital school sessions. We wanted to put on today's event addressing the topic of consent in the law because it does come up pretty often in our school sessions. And in the later years of high school, it's probably a topic you'll either experience yourself or one of your peers might. Consent isn't just something you have to deal with in a face-to-face situation either. It is relevant to online interactions as well. So hopefully our panel of judges will help you learn more about this tricky topic today. Please note that this topic, there will be some mention of things like sexual assault and other non-consensual acts. Nothing in detail though, but if you're not comfortable hearing about these, this might not be the right event for you. Since we have a few of you attending, we'll keep your mics on mute so we don't have sound issues. But if you have questions for judges at any time, please type your questions into the chat box. You'll see someone in the chat box called Ask Me a Question, and if you just want to ask that question to them. Also, if you haven't already, if you could please turn your cameras on, and that way all the judges will be able to see you as well. We also have Eve and Kirk joining us on our screens today, and they will be providing Auslan interpretation. Thank you both. Our panelists today are Judge Riddell, Judge Hassan, and Judge Doyle. I'll hand over to them to introduce themselves, starting with Judge Riddell, who is joining us from a separate location today. Please go ahead, Your Honour.
Thanks very much and welcome everyone to this topic. I'm joining you from a circuit court in Ballarat. My name's Trish Riddell. I've been a judge since 2017. I'm just going to give you a thumbnail sketch about my history. Firstly, my personal history is that I grew up in a family of 7 children and some of my siblings had disability in the form of cystic fibrosis, which is a chronic health condition. And so as a kid, I grew up watching my parents have to advocate for their rights and their health treatment. And I think that instilled in me a very strong sense of criminal justice and, social justice. That is advocating for people who are less fortunate. And I think that naturally flowed into my later interest in the criminal justice system, where one can be an advocate for people who are disadvantaged. So I did arts law at Monash Uni straight after school. I then entered a criminal law firm, was a solicitor for a little while, and at 26 I became a barrister. And my life as a barrister was mostly in the criminal law, mostly in defence work, where I found myself telling the stories of people who had often experienced social disadvantage, deprivation and difficulty, and that led to their entanglement often in the criminal justice system. I later became a prosecutor, prosecuting and telling the stories of witnesses and victims in serious criminal offending. I also worked in other areas of the law, coronial inquests, medical matters, and one of my pet projects was as a prosecutor for the RSPCA, prosecuting animal cruelty offences. I was appointed in 2017, and just as a little side note, when I was appointed, and I think now there's about half and half women and men on our bench. When I graduated from Monash Uni in 1993, there were no women on the county court or the Supreme Courts. So times have changed, and I think also our bench is a really diverse bench reflecting the community that we serve. As a personal note, I'm a mother to a 21-year-old, an 18-year-old and a 16-year-old. So I certainly know that consent and sexual matters are a hot topic for your age group. So I commend you for joining in, and hopefully we can shed some light on those topics today. Thanks.
Judge Doyle, if you'd like to go.
All right, thanks. I too studied arts law at Monash University, graduating a few years before Judge Riddell. I then obtained work as a solicitor at Legal Aid, as what they call a duty lawyer, so appearing in magistrates' courts in Dandenong, Melbourne, and then in the Children's Court in Melbourne for a number of years. I also worked in that period for the Aboriginal Legal Service in criminal defence work, so that was all criminal defence work in that period. I also worked in Legal Aid's main section in jury trial work for a few years as well before going to the bar way back in 1995. I did criminal defence work for really most of the next 10 years. I spent about a year in Darwin working for the Aboriginal Legal Service up there in 2001, and that was all criminal defence work as well, until perhaps in around 2006 I started prosecuting. I crossed over to the dark side, some say, or others might say it's the bright side, depending on what perspective you have. And I then mainly prosecuted with some defence work until around 2018. I then worked as a Crown prosecutor, which is really an in-house barrister for the OPP, which is the Office of Public Prosecutions. And I did that for a few years before I was appointed as a judge in October 2019, as it happened on the same day as Judge Hassan, who's sitting next to me. So that's my background in the law. It's all been court appearance work, both in defence work and in prosecution work. On a personal note, I too have children, two boys who are in their 20s now, so they're in their a little bit older than those of you watching, but not so far removed. And as Judge Riddell said, we have an awareness that these sorts of topics are highly relevant to your age group. But that's my background, all criminal law. And then as a judge, I'm a criminal judge full-time, so it's more criminal law 100% of the time. So that's my history, and I'll hand over to Judge Hassan.
Good afternoon, everyone. Well, I wasn't certain what I wanted to do with my life when I finished secondary school. It's a very long time ago now. I was more interested in artistic pursuits and things of that nature. So the law certainly wasn't something that I thought I would always do or wanted to do, and I certainly didn't have any family connections. I didn't study law until I was in my 20s, when I went to Melbourne University and did an arts law degree. And when I finished my degree, my first job was as a judge's associate. Perhaps unusually, I never practiced as a solicitor. I got my first job working for Justice Marilyn Warren in the Supreme Court. Some of you may know she went on to be the Chief Justice. I didn't work for her then. I worked for her when she was a commercial judge. And that was a great learning experience. An associateship is a great learning experience for practicing law. I enjoyed the work, but I always wanted to do criminal law. So when I went to the bar in 2003, like Judge Riddell and Judge Doyle, I was a criminal barrister. I did both prosecution and defence work. Like Judge Doyle, I was for a period a Crown prosecutor, which is really just a barrister who exclusively does prosecution work in the Supreme Court and the County Court. And I did that for 6 years, and I was at the bar, the independent bar, for 10 years. So I was a barrister for 16 years doing criminal work. I did some other bits and pieces, some coronial inquests, things of that nature, but mainly criminal work. I was appointed on the same day as Judge Doyle, so I've been a judge of the County Court since October 2019. I sit exclusively in the criminal list, and I would estimate about 70 to 80% of the work I do involves allegations of sexual assault, rape, and the sexual abuse of children. So it's a lot of the criminal work that comes through this court is about those type of offences, which the topic that we're speaking about this afternoon addresses. So I hope you all enjoy this afternoon's talk.
Thanks for those wonderful introductions, judges. I've got some questions for the judges to start the conversation, but as I said, please feel free to type your questions into the Q&A box at any time. Just a reminder that our panel cannot give any legal advice or comment on some specific cases, nor can they comment on legislation that is not being passed. I might start with a question for you, Judge Doyle.
Yes.
How is consent defined?
All right. The question of consent and what it means is relevant in the law to quite a number of charges, but there are two main charges where it's relevant. The first is rape. The second is sexual assault. So you understand, rape is sexual penetration without consent. Sexual penetration means the penetration of a vagina or anus with a body part or an object, and it also includes penetration of the mouth by a penis. These are the circumstances of sexual penetration. It becomes rape where it occurs in circumstances where there is no consent. The second charge where it's relevant, and there are a range of other charges, but these are the two most important that most commonly come before the courts, is sexual assault. Sexual assault is touching in sexual circumstances without consent. That offence used to be called indecent assault. It's now called sexual assault in the Crimes Act. So it's sexual touching or touching in sexual circumstances. Just so you understand, Judge Hassan referred to charges that relate to the sexual abuse of children. The two main charges there, and although there are many, sexual penetration of a child under the age of 16 and indecent act with a child under the age of 16. Now, for children under the age of 16, the law presumes that such sexual activity will cause harm, and therefore consent is not relevant to those charges. They are proven by the Act themselves, unless the complainant, that's the person making the allegation, unless the circumstances are such that the accused person is not more than 2 years older than the complainant. In those circumstances, consent is a defence, but otherwise consent is irrelevant, and the reason is because the law regards sexual activity with children under the age of 16 as harmful to those children. So that's when consent is relevant. So what is consent? Under our law, consent means free agreement. And there are two states of mind involved in the issue of consent. The first relates to the complainant or the person making the allegation. Is that person consenting, or in jury trials, have the prosecution prove there was no consent? As I say, consent means free agreement. Now, free agreement covers all the circumstances you might expect that it does, such as where the complainant says no to the accused before an act of penetration or sexual touching takes place, or where a complainant physically resists. It covers those sort of circumstances, but the legislation also has a series of circumstances where a complainant is regarded as not having given free agreement. And Judge Hassan will talk to you about those circumstances. In certain circumstances, if they're proven, the complainant is regarded as not having given free agreement, as I say. One of those circumstances is where the complainant does not do or say anything to indicate consent. If that's proven, then the law regards that as indicating there was no consent or no free agreement. Now, Judge Hassan will go through some of the other circumstances relating to the use of alcohol or the question of intoxication and situations such as where the complainant is in fear of force, those sorts of circumstances. But free agreement, and that'll be a matter for a jury to determine in this court, and it's a matter the prosecution must prove beyond reasonable doubt there was no free agreement. The second state of mind that's relevant is the state of mind of the person accused. And the prosecution has to prove that either the accused believed the complainant was not consenting or did not believe the complainant was consenting or gave no thought to whether the complainant was consenting. If the prosecution proved either of those two circumstances, they will have proved the accused did not have a belief in consent. But the belief of the accused is required to be reasonable in the circumstances. So the third situation where the prosecution will have proved the state of mind of the accused is where an accused believed the complainant was consenting, but the belief was not a reasonable belief in the circumstances. So there's a range of states of mind of the accused the prosecution is required to prove beyond reasonable doubt as well. And again, there are a series of factors that relate to that finding, the state of mind of the accused, which Judge Hassan will deal with in some detail. So that is the definition of consent. Free agreement. The prosecution have got to prove that in any case, and the prosecution have to prove that the accused did not have a reasonable belief in consent or free agreement. So that is the legal definition. There are, of course, considerable complexities to all of this, and that's all I wanted to say at the moment. There are other matters that can be dealt with in that, but the next issue, I think, is the next question, so I'll hand it back to you.
Thanks, Judge
Jasmin.
Doyle. Judge Hassan, I might ask you a question now, and that is, what is needed for consent?
All right, so as Judge Doyle just explained, consent is now defined at law as free agreement. And I think it's really important at the outset to recognise that the law in respect of sexual assault and rape has changed and developed a lot. The law's criticised a lot. There's a lot of discussion in the media about the law of sexual assault and its failings, but it's important to recognise that it has developed a lot and in the right way, I would suggest. So what's needed to give consent? There are lots of circumstances where the law recognises that a person isn't consenting. It's not just simply situations where a person, a complainant, a victim is fighting or is saying no, no, no. The first one is the age required to give consent. Now, Judge Doyle's talked about this, but I think it might be a topic that you're interested in. If you're under 16, you can't consent to have sex with an adult, which the law defines as a person over 18. So it's said that consent is disabled for young people. We might talk about that a bit more later. You also cannot consent to sexual activity or sexual penetration if you are cognitively impaired, intellectually disabled, but to a very profound extent, to the extent where your disability means that you are unable to understand the sexual nature of the conduct. So it's certainly not the case that anyone who has an intellectual disability or who is cognitively impaired cannot consent. But someone who is profoundly cognitively impaired, who can't understand the sexual nature of activity, cannot give consent. Now, another topic or another circumstance in which there may not be consent is one that we see a lot, I would suggest, in cases, and that is where a complainant, and that means someone who complains about being sexually assaulted or raped, that's the word we use, where a complainant is so affected by drugs and alcohol that they are incapable of consenting. Now, that doesn't mean that someone simply had a bit too much to drink at a party and it's a bit disinhibited. I'm sure you all know what that means. Just maybe 1 or 2 drinks too many, and you might do things that you wouldn't normally do. You might do things that you might regret the next day. That's not what we're talking about. It's to be so affected by drugs and alcohol that you're incapable of giving consent. What might be a circumstance where we see that? There was recently a rape case before this court where a complainant was found lying face down in the street in the middle of the night in winter with the rain pouring down. She was picked up by 2 men in a car, and there were allegations of rape which were proven, and the defendants were found guilty. That was a circumstance in which a complainant was drunk or intoxicated to the extent that she was incapable of giving consent. And you can see how that's made out by the circumstances. That's not simply a case of someone having a couple of drinks too many at a party and being disinhibited. You see that that's a case of someone lying face down in the street, in the pouring rain, in the freezing cold. And you can see how that is, well, there's circumstances where someone are said to be incapable of giving consent because they're so affected by drugs and alcohol. Other circumstances that the law recognises where consent isn't given or where free agreement isn't made out are circumstances where a complainant might be frightened or where they just submit. Fear might be an obvious one if there are threats or anything like that. If a person just acts on those threats or submits because of those threats. But sometimes the facts in any situation can be a bit more complicated and a bit more subtle. There can be power imbalances where a person feels that they're unable to speak up and able to express what they feel, and that might be a topic we discuss a little bit more later. But circumstances where there is fear or submission might be other circumstances that the law recognises that free agreement has not been given. Now, of course, all this can be further complicated because, as Judge Doyle explained to you, when we're looking at the law of sexual assault, rape, we're looking at 2 states of mind. We're looking at the state of mind of the victim or the complainant, and that's the issue of consent. But we're also looking at the state of mind of the perpetrator or the defendant, the alleged perpetrator or the defendant. And what has to be proven is that a defendant has no reasonable belief in consent. So his or her state of mind is also looked at. And I think you can see, if we go back to the alcohol, the intoxication example, if we were in a situation where a complainant says, well, I didn't consent because I was drunk, I was intoxicated, I didn't know what I was doing, the defendant in such a case might argue, but she was behaving in a way that made me think she was consenting. She seemed free, she seemed friendly, she seemed disinhibited, she seemed enthusiastic. So you can see how sometimes there are complications around the law of consent. And there are 2 different states of mind. And in some circumstances, can be very complicated questions for the jury to answer. So all cases turn on their own facts. And the law of consent has some very, very tricky, very, very complicated circumstances of human behaviour that the jury who make the decision have to look at both perspectives. And of course, it's always for the prosecution in criminal cases to prove beyond reasonable doubt the case for the prosecution.
Thanks very much, Judge. I might ask a question for Judge Riddell now, and that is, how do online or virtual interactions complicate consent?
That's a really hot topic for young people your ages, those who are listening, because, of course, we're all very traceable now. All our activity can be followed, whether it's through text messaging, emails, direct messages on Instagram or Facebook Messenger. And those sort of things well and truly come into trials, especially when we're dealing with sexual allegations between young people. So I want to say one thing about consent before I move on to how those matters can play into criminal trials. Consent relates, as you've been told by Judge Doyle and Judge Hassan, to what is happening in those moments around the sexual activity. And I'm sure you've all heard the cup of coffee type analogies. That is, I said I liked coffee, but I didn't feel like it then. Or just because I said I was interested in coffee didn't mean I wanted to have coffee that night. So consent's got to be about what's happening during that particular sexual activity. But that's not to say that the lead-up interactions between those two people are not relevant. And that's where we see with a lot of young people, their online type of interactions can come into play because, as you've been told, it's the consent or lack of consent on the part of one person and the belief in consent on behalf of the other person. So lead-up interactions can include, and as I said, often in trials where there are young people involved, they do include those text messages, maybe emails, although they're a bit old-fashioned now, but direct messages on Instagram, Facebook messages. That can include your words, your emojis, your photographs or videos that you send to someone. So the first thing I always tell school groups is think about that next time you're going to send something, because picture a room full of strangers, a jury of 12 people, the judge, the barristers, solicitors, all examining what that interaction has been in the lead up to whatever sexual activity has occurred. So even though consent and the belief in consent has to be present in the moment, those virtual interactions we are seeing more and more are part of the evidence in a criminal trial where young people are involved, and they can be relied on by a complainant who says, have a look at my words in those text messages. I never expressed an interest. Or they might be relied on by the accused to say, I really had a belief because this is the type of discussion we were having beforehand, or these are the photos or the videos I was sent beforehand, and therefore when it got to that moment, I thought I had a good basis for believing in consent. Part of my amusement sometimes is in watching older barristers try and interpret the online communications between young people. My favourite example I give to people is an older barrister who read a text message which simply said, I'm busy ATM, which you would all understand, but this older barrister said to the witness, so you were too busy to go to the bank. Clearly was not what it meant. But as I said, be careful with your online interactions, and particularly those sort of lead-up interactions, because we do see those materials in a criminal trial. Virtual interactions are also relevant where people are exchanging photographs or videos that might be sexually explicit. They can, if it's a person under 16, a person could be charged with creating or producing child pornography. That's a film or a photograph or even a computer game that depicts that type of activity. If you're over 18, there's now an offence of sexting, which is a Commonwealth offence, and that can include sharing an image of another person without their consent, a sexual type of image. So the law is catching up with the virtual and online interactions of people by trying to contain them and create offences where that's appropriate, because people's privacy is being breached by the sharing of their images online. So it's a word of caution to really think before you would engage in anything online that involves either exposing yourself or another person to that type of publicity.
Thanks very much, Judge. I might ask a follow-up question on that, and that is, can you give consent if you're under the age of 16?
Only to someone who is within 2 years of your age. So as Judge Doyle and Judge Hassan have said, the law presumes that sexual activity is premature for those under 16. So anyone 2 years older can be charged with a criminal offence. If there's a 2-year age gap or less, then consent can be given.
Thank you very much, Judge. Judge Doyle, I might ask you a question now, and that is, what are the consequences of breaking consent laws?
Well, the consequences of breaking a consent law as they relate to the charges that I've discussed earlier, rape, sexual assault, are that if you were to commit sexual penetration without consent, that's rape, or sexual assault, that's touching without consent, you could be charged with either of those offences. You may be dealt with in the case of a sexual assault in the magistrate's court. You may be dealt with in the case of sexual assault and rape in the county court, and you would have to have a trial. In the event that you were convicted, you would quite likely end up receiving a sentence of imprisonment. And additionally, there are other orders that can be made in relation to sexual offences with respect to the Sex Offenders Registration Acts, depending on the charge and whether the offence involves a child. But to break consent laws by engaging in sexual activity without consent will result in very serious charges, court proceedings, and quite likely, in the event of a conviction, a period of imprisonment. For instance, for a rape charge, conviction almost inevitably ends in imprisonment, not every time, but almost inevitably. And the sentencing law now involves standard sentences for some of these charges, and the standard sentence for rape is in fact 8 years imprisonment. Not that that's always the sentence imposed, but that gives you some idea of the severity of the penalties involved in such offences involving the breach of the consent laws. Now, there are a range of other offences, some of which Judge Riddell's talked about, which involve issues of consent. But breaching consent laws by engaging in the sorts of activity that I've described and that which Judge Riddell's described would almost certainly see you charged with offences.
Thanks very much, Judge Doyle. Judge Hassan, I might ask you a question, and that is, what are some facts about online consent that people might not be aware of?
I think the big issue with online consent that some people may not be aware of, but I bet you as young people are aware of, is the issue of deceit, and the issue that in the online world, people can present themselves in ways that aren't truthful. People can adopt online personas, people can make out they're anything. And one of the things that we see a lot of is adults who use the online world to communicate with young people for sexual purposes. They hide the fact that they're adults. They may try and use the persona of another young person. They may try to ingratiate themselves in online chat. That may become sexual. But the issue of consent is complicated because of this ability to deceive in the online world, the ability to present yourself as something you're not. And we've certainly seen in the world of sexual assault, sexual offending, a lot of cases that involve adults who are looking to interact with children using the online space to do that, because they know that it's a space that a lot of young people use. They know that it's a space where a lot of young people like to talk to other young people about what's going on in their life. And adults go there and often misrepresent themselves. So it's a place where young people such as yourself can be vulnerable, and you need to keep your guard up. And that complicates the issue of consent, because someone can be online talking with someone that they think is another young person, and in fact they're talking to a middle-aged offender. So that can be a real issue with online communication and the issue of consent online.
Thank you, Judge. Just a reminder for all of you on our screens, please use the Q&A function to send in your questions, and we'll be able to ask the judges your questions. Judge Riddell, I might ask you a question next, and that is, what advice can you give to someone who wants to be clear about giving and receiving consent but isn't sure how to go about it?
Well, consent can be communicated by words, but it can also be communicated by actions. And I think you'd all understand at a point where you are, sexual activity can be confronting, confusing, new, different experiences. And it's sometimes awkward and embarrassing and difficult to communicate what you're really wanting to do, or to understand what you think the other person's communicating. Judge Doyle's just told you the type of penalties that there are when sexual activity happens without consent. The message is, be really clear as you can be in your communications with someone when you're engaging in sexual activity. You might be aware that in some parts of Australia, there are some slightly different definitions of consent. Ours is free agreement. New South Wales is expanding on that. And some of the universities actually require, when you enrol, that you do a bit of an online survey about your understanding of consent and appropriate sexual activity. And the definition that they use is about enthusiastic consent. And that's quite a good message to have in your mind. Is this person giving me enthusiastic consent, either by their words or by their actions? Even though they might have given me enthusiastic consent on another occasion, are they giving it to me now? Even though they started off giving me enthusiastic consent, have they changed their mind, and are they communicating with me now that they have withdrawn their consent? Because free agreement not only includes the initial giving of consent, but the freedom to change your mind. So consent can be withdrawn, and that can be communicated also by words or by actions. So even though it's difficult and awkward enough, and you throw in something like alcohol or any other substances, illicit drugs, it becomes more complicated on the part of both people. You've really got to have in your mind enthusiastic consent.
Thanks, Judge Riddell. Judge Hassan, I might ask you another question. What happens if you share a photo with your boyfriend or girlfriend and then they share it to other people?
Well, I think it was Judge Riddell, or it might have been Judge Doyle who touched on this. There can be, I think the offence was called sexting, but sharing photos of another person that are sexually explicit or sexual in nature can result in criminal charges. So if somebody does that, they could get themselves into a lot of trouble if they're photographs of you that they've shared and you make a complaint to the police. So it's something that, you know, as Judge Doyle said, sexual offences are very serious, and you might not think that something like that is very serious. You might think that that's something that happens all the time. I hope it doesn't, but it could result in someone being prosecuted.
Thanks, Judge. You all touched on this in your introductions to start with, but you all mentioned that there's a lot of cases these days that you hear in regards to sexual offending. Judge Doyle, are you able to expand on perhaps why there might be so many? Do you think it might have something to do with maybe the complainant not understanding consent, or?
Well, look, I think there are a few reasons the county court hears so many sexual offences. But firstly, it is prevalent offending. The rate of reporting of sexual offences seems to me has increased considerably in recent years, even to the point that we are now dealing quite often with offending that took place 20, 30 years ago, even longer than that. There's a lag in reporting times for a lot of these offences. People are now more willing to report these sorts of things than they were in times gone past, and the county court is now dealing with a high rate of complaints of serious offending, as I say, going back many years. Secondly, I think one of the reasons it takes so much time in the county court is that compared to other offences, very often the evidence in a case will come from the complainant alone. It will be one witness saying, this is what happened to me. There was sexual activity, it was without consent. And that'll be the only evidence in the case. It seems to me, for that reason, it's the rate of pleading not guilty in sexual offences is much higher than it is in other offences. And therefore, we hear these cases as trials much more than we would, for instance, a theft or an armed robbery or drug trafficking, where very often the evidence is overwhelming. Drug trafficking might include monitoring people's phone calls, for instance, where they're making offers to sell drugs on the phone. And there's not really much way out in those circumstances for people accused. So the rate of pleading not guilty in sexual offences is much higher than it is in other cases. So there's two factors: there's prevalence, increased reporting, and then for the time it takes in our court, there is the fact that people plead not guilty at a much higher rate, which means it has to be a trial, which means it takes a lot more of the court's time to deal with these cases. And as well as that, many offences, non-sexual offences, are dealt with in the magistrate's court, whereas the bulk of sexual offences are seen as too serious to be dealt with in the magistrate's court, and therefore they are heard and determined in the county court. We really are the court in which sexual offending is dealt with by and large. We deal with nearly all of it. The Supreme Court doesn't deal with a great deal of sexual offending. So there's a range of reasons. Prevalence, not much of it is heard in the magistrate's court. The county court hears most of it, and quite a lot of it ends up being trial work before juries, and these days by a judge alone from time to time as well. So it seems to me that's the reason why those are the reasons why it occupies so much of our time in the county court.
Thank you. We have another question that's come through, and that is, do you think that young people are starting to understand what consent is more, or why do you think that it might be confusing sometimes? I might hand that over to Judge Hassan.
I think that sexual assault is widely discussed in our community these days in a way it wasn't even 10 years ago. So I'm sure that young people like yourselves are becoming much more aware of the issues in the law of rape, sexual assault, and the issue of consent. So I'm sure that you are becoming more aware. As Judge Doyle was just saying, we get a lot of cases that have taken a long time to come to court that involve adults, sometimes quite elderly people, but in the work I've done, I've certainly seen cases where the complainants have been young people, still people in their teens. So I think the issue of consent is much more widely discussed, and I hope much more widely understood in the community. I think confusion around the issue is for the reasons that we've all been discussing. When it's two states of mind, it's the complainant giving consent and the defendant or the accused, their reasonable belief in consent, and all that area for misunderstandings when things like alcohol are thrown into the mix. So I think that, or what Judge Riddell was talking about, a situation where there's been a prior relationship, where there's been some discussion about, well, maybe I'm interested in this, and maybe I'm not interested in that, and maybe I was interested yesterday, but I'm not interested today, and all the misunderstandings that can evolve and erupt in those situations.
Thank you, Judge. We've had another question come through, which I might ask Judge Riddell to answer, and that is, how could one contact the authorities, or what should they do if if sexual photographs of yourself or someone else's were leaked to persons who weren't intended to see them? Sorry.
Sure. Well, the simple answer is to contact the police, because again, if you haven't given permission or consent for your photos or videos to be shared beyond the person you sent it to, then that is a criminal offence, and you would want that investigated. As for the capacity to stop that circulating, that's as you guys would all understand, that's very difficult, because once your images are out there, it's very difficult to get them back. But part of the reason, obviously, that offence has been created, the sexting offence, or the creation and distribution of child pornography type of offences, so let's say it's someone who's 16 or younger, is because people will be sentenced, and that will send a message to deter other people from doing likewise. So that's really important in this sort of activity, that offences are pursued to deter other people from engaging in that type of activity.
Thank you. Judge Doyle, if you're under 18, are there different charges applicable?
Under 18, as Judge Riddell pointed out, the relevant age for consent is 16. Under 16, this is for the complainant. Where the complainant is under 16, consent is a defence for somebody who is not more than 2 years older. As I understand the legislation, if the complainant was 14, then it would be a defence for someone who is not more than 16 or 2 years older than a 14-year-old complainant, which would, of course, leave scope for somebody to be charged who was older than that. So that's in that sort of scenario for an underage offence. However, in circumstances where there is, for example, sexual penetration without consent, age is not relevant. That would be rape. You could be charged with rape. If you were under 18, that matter would probably be dealt with in the children's court. That's the difference. The charge would be rape in circumstances of sexual penetration without consent, but the venue for the court hearing would be the children's court. Just because you are under 18 doesn't mean you can't be charged with all of the offences in the Crimes Act, subject to what I said about the age gap. But any circumstances where the prosecution can prove there was no consent and that the accused person, in this case a child, reasonably believed there was no consent, the charge would be the same, but the venue would be different. The venue would be the children's.
Could I add something? Yeah. If you're under 16, if a complainant is under 16 and they complain about being sexually assaulted, sexually penetrated, there's a charge of sexual penetration of a child under 16, and the prosecution doesn't have to prove lack of consent. So consent's not even an issue. That's what we've all been discussing at some length today. so that there is a different charge where consent is irrelevant. If an act of sexual penetration or a sexual assault has taken place and it's a child under 16 and it's a perpetrator 2 years older, the charge is sexual penetration of a child under 16. That age can be taken out to 18 when an alleged defendant is someone in a position of trust, supervision, and authority, I think are the words. That is someone like a teacher or a sports coach or someone who's in a relationship of authority over the child. And then it's the age goes up. So it's anyone effectively under 18, and then consent is not an issue, it doesn't have to be proven.
Thank you. We have another question that's come through from another student, and that is, do you believe there is stigma around reporting sexual abuse, harassment, and rape? If so, what are some strategies to reduce this, especially in circumstances where the perpetrator is a family member? I might pass over to Judge Riddell.
Sure. Look, I think it's a really difficult scenario where there's a family member, and we'd be lying if we didn't say that was emotional, traumatic to bring forward those charges and those allegations. But I think what the law has seen, and what the three of us have seen during the course of our careers over the last 20 to 30 years, is that the law is really catching up with, and has caught up in a lot of ways, with the community's understanding of the fact that sexual offences occur, the fact they occur within families, the fact they occur within institutions, and there are actually a lot of measures now, and any of you in year 11 or 12 might have understood this, measures in the legislation like the Evidence Act for vulnerable witnesses. So vulnerable witnesses can be people making allegations of sexual offences, and in particular any child or person under 18. And some of the measures that are in place, for example, are the witness, the complainant, the victim, doesn't have to come into the courtroom and confront the person they're accusing, so they can give their evidence from a remote room. And because of COVID, we're much more used to remote facilities, but that's actually been in place for a long time in the law. So the witness can be in a different room with a support person. These days, in fact, the court and the Office of Public Prosecutions has access to support dogs. So a little bit like guide dogs. You'd all understand a witness who's anxious, nervous, feeling emotional about what they're giving evidence about might have the support dog with them in that remote room just as a comfort. I've had plenty of children and young people give evidence. Perhaps they haven't had the dog, but some have had, say, squeezy toys or plasticine, things that can just help centre them and help them give their best evidence. So it's a bit of a long way round to answer the question, but those sorts of challenges to a person making allegations of sexual offences against them, there are measures in place in the court processes now to try and help those witnesses give of their best evidence. And that's a real recognition by the law that it's really difficult and that it's challenging and that it can be traumatic and emotional. As far as whether there's a stigma, that's probably a social question, but I think because there's this growing understanding of the prevalence of sexual offending, that's becoming less and less.
I was going to add, I think there is a stigma, but an important protection for complainants is that you're not named and identified in the media. So when you go away from this talk this afternoon, go and have a look at a newspaper report about a sexual assault case, and you'll see that the complainant's not named, and nor should there be any information that helps identify the complainant's address or any information of that kind. So that's an important protection because it is understood there is shame. And the other important protection is that when a complainant gives evidence, they can have what's called a closed courtroom. So some people have got to be there. The judge has got to be there. The jury's got to be there. The barristers, the accused, but not anyone from the street, because courts are open. Most court cases, people can just walk in and have a look and see what's happening and watch the proceedings, but not in a sexual case. It's a closed courtroom, so that someone who's talking about sexual experiences and non-consensual sexual experiences doesn't have anyone walking in listening. So they're important protections.
Thanks, Judge. I'm conscious of time, so I think we've got 2 more questions. We've had another question come through, which is, what happens if you think you're engaging in sexual activity with someone who's 18, but it turns out they're lying and they're actually younger, perhaps 16 or 17?
All right, this is an interesting question, and it is dealt with in the legislation. I won't perhaps take those age numbers that were given, but Judge Hassan's referred to the offence of sexual penetration of the child under the age of 16. So, for instance, take for an example where the complainant is 14, but tells the other person they're 18 and reasonably appears to be 18. If the person accused has a reasonable belief that the complainant is older than 16, that is a defence to the charge. So that's a matter for in our court for the jury to determine. And in those circumstances, the onus, if it's proved that the complainant in the case was 14, the onus does shift to the accused to prove that they had a reasonable basis for believing that the complainant was older than 16. So that really covers the sort of scenario the question addresses, it seems to me, without dealing with the precise ages of the question. But in circumstances where someone is pretending to be much older than they really are, there is a defence available to an accused person of a reasonable belief that that person was older than 16. Now, there might be some circumstances where the belief is so absurd that it won't be accepted by the jury. I've certainly had cases where complainants have told the accused that they were 18, for instance, circumstances where the parent of the complainant has found out about the relationship and told the accused, look, my daughter is 14, and the accused has nonetheless continued in the sexual relationship. And as you can imagine, it gets pretty hard to claim in that scenario where the parent has told the accused the true age of the complainant to persist in a defence that the complainant was older than 16. But there is a defence available depending on a reasonable belief the complainant was over the age of 16. Now, there are other offences, some of which Judge Hassan referred to, that involve a slightly older child in positions of circumstances of authority, but the same principles apply, so that there is this defence available depending on the belief of the accused as to the age of the complainant. So I hope that answers that particular question.
I think it does. Thanks, Judge. Did you have anything to add there, Judge Hassan?
No, that's right.
Thank you. Looking at time, I think we might finish with one last question. It is slightly not related to the subject, but is there any advice you'd like to give to the students if they are considering a career in the law?
Perhaps Judge Riddell.
Judge Riddell.
Oh, it's simple. Go for it. I've absolutely loved my career. The law could be a sort of traditional path that you've heard the three of us have travelled. Judge Hassan had a more interesting backstory before she entered the law, but all of us have travelled a pretty traditional path of being barristers and then becoming judges. But there are so many ways to use a law degree, whether it's going to work in a corporation to give advice on contracts, whether it's working in a media organisation to give advice about what's possible on TV or what might be defamation or those sorts of things, whether it's giving advice to government about policy or research or going behind the scenes of legislation. A law degree can really open a lot of doors and it can be used in a lot of creative ways, or you can come on this wonderful traditional path that we're on, where we hear a lot of people's stories and have a very interesting career that throws up different challenges every single day.
Thanks, Judge Riddell. Judge Hassan?
Completely agree. If you're interested, do it. The law can take you in lots of different areas. If you follow the path that we have into criminal law, I found it absolutely fascinating. I enjoy my work. I find my work fulfilling, and I recommend it highly. If you start off doing the degree and you decide it's not for you, it's a good generalist degree. It can take you a lot of other different places. So go for it.
Well, I agree with all that. As far as criminal law is concerned, if you do like working with people, if that's your interest, and you enjoy a career that gives you perhaps a bit of adrenaline from time to time when you go to court, and you like that kind of aspect of it, then I would recommend criminal law as a career to you. I found it very fulfilling. It's never boring. It's often exciting. So I would encourage you to pursue that. And if you do law, make sure you read the cases from a very early stage.
A big thanks to all of our judges today, Judge Riddell, Judge Hassan and Judge Doyle, for a great discussion, and thank you to all of you who attended and asked some great questions. If you do know of anyone who couldn't make it today, we will be publishing the recording of all our events from Law Week on our website in the next week or so. Finally, we have our final Law Week event on Friday. It is our highlight event, and it's to do with all things sentencing. It'll be featuring Chief Judge Kidd and Deputy Chief Judge Sexting. If you haven't already booked in to go and attend it, I would really encourage you to attend if you can. And that was just jumping onto online and going to countycourt.vic.gov.au/lawweek, and you should find all the registration details there. With that, it does conclude our event. So thanks again to everyone for coming along, and thanks very much, judges.
Thanks very much.
Thank you. Bye-bye.